Hi, and thanks for joining me for this edition of Legal Q&A. All right, so let's get started. So today we have a question concerning New Jersey's DYFS, Division of Youth and Family Services. So this question says that my boyfriend's mother is angry and is causing trouble for me. I'm on parole, and she called DYFS saying that I was abused when I was 16 years old. This asker is now 34 years old, and she has a 4-year-old son, and she's concerned as to what might happen. Well, this is a hard question to answer because there's a lot of variables in here. The simple fact is that you can do very little to stop someone from calling DYFS, or in this person's case, calling the parole officer and suggesting that there's a problem. Oftentimes, when you call DYFS, they are obligated to investigate. So the same way that if you take your child to a hospital and the hospital believes that the child's injuries are a result of neglect or accidental overdose of an adult pill, anything like that, they are obligated to call DYFS, and then DYFS conducts an investigation. So in this situation, it's likely that DYFS will investigate, but the real solution here is to just be truthful, to explain to any investigator or to a parole officer exactly what's going on, and hopefully there'll be no problem. This one's a little difficult to answer because of the variables. All right, now here's an interesting one. What am I entitled to is the question. I live in the city, and it was 11 p.m. and I got a bang on my door. Then transit police told me that my car had been involved in an accident, and it was a result of a police officer who was en route to an emergency, lost control, and then hit into the driver's side door of this individual's car. Okay, well, first of all, you should have insurance on your vehicle. And if you have collision insurance, then you simply submit a claim to your insurance carrier and you provide them with the facts. Now you'll say to me, but what about my deductible? It's not fair. Well, you can submit it to your carrier, and your carrier will ultimately file a subrogation action against the City of New York and the police department in the hopes of not only recovering the money that they paid out to you, but getting your deductible back. Now, you could say, well, why don't I just sue the police? Well, it's not as easy as just suing another individual. If this was not a police officer, but another person who was not a cop, you could, in theory, sue that person instead of going through your own insurance and get their insurance company to pay you. That way you don't have a deductible. Now, in this case, though, this is when you say the city here, it's referring to Jersey City in New Jersey. In this case, you're going to have to comply with all of the Title 56 regulations about suing a municipal entity, meaning you're going to have to file a notice of tort claim. Then you're going to have to wait 6 months to file a lawsuit. By the time you get to the police, and they have various immunities, and if they're en route to an emergency situation, the likelihood is that they're going to have an immunity for that too. So you don't really have any viable claim against the police. And even if you do, by the time you actually get to the police, it'll be 6 months later. So go through your own insurance company. All right, now, this question. Does an agreement with a mediator and signed by a judge hold the same weight as an order signed after a full hearing? This is a good question. So why do people go to mediation? Well, mediation, unlike arbitration, which is strictly enforceable after the arbitration, it's a binding decision. Mediation is non-binding. It's something that the parties enter into, trying to resolve an issue, and by doing so with a mediator, they save themselves litigation expenses and expenses on an attorney. So people select mediation as a less expensive way of resolving disputes. So when you go to a mediator and you resolve an issue, there's something that is going to come out of that mediation session. If it's a divorce and you're mediating your divorce, you'll get a divorce settlement agreement that the mediator will draw up, or your attorney, or depending upon the circumstances. If it is a personal injury case, and the mediator helps you resolve the case. Either the mediator, or if you have attorneys involved, they'll draw up a settlement agreement. And ultimately, it's submitted to the court, and the court signs it. Once the court signs it, it has the same force and effect as an order, as if you had had a formal hearing before, the judge. So the idea is that you're bypassing through mediation all of the steps that involve litigation and expense. You don't need discovery, you don't need depositions, you don't need motion practice. And you're resolving it with the mediator, but the end product that is submitted to the court is then signed and becomes an order or a signed settlement agreement, and then it does have the same force and effect, the same weight as this person asks, as an order signed after a full hearing. Okay, and the last one for today. Was this legal to do? My niece used my name and phone number for a reference on her school loan, and I didn't give permission for her to do so. She hasn't paid anything, and now the student loan people are calling me constantly. Okay, so completely annoying, that's for sure. When bill collectors start calling and it's incessant and they're calling all day long, it's really upsetting and unnerving. So I get where the question, where the asker of the question is coming from. But let's talk legally for a second. So was it permissible for her niece to use her name and phone number as a reference? Well, it depends. There's oftentimes on applications where it'll ask you for a reference and you provide people that you know. It's not illegal for you to put somebody that you know down as a reference. It might be common courtesy to say, hey, by the way, I'm applying for a student loan, I'm going to put you down as a reference. But there's nothing illegal about this. Separately, this question does not say that the woman whose name was used as a reference is a guarantor or a cosigner under the agreement. So therefore, the student loan cannot be collected from the student's aunt, because that's who this is that's asking. The aunt is asking about her niece. So it's really just an annoyance factor of this student loan company calling. And even if the niece had not put her name down as a reference, when you default on a loan or when you stop paying a loan, and collection agents or collection companies come after you to try to get reimbursement, the first thing they're going to do is run a full background check on the person who is defaulting. And the way that the background checks are set up, depending upon how complex of a check you do, it will produce for you known family members, known affiliates, known friends. It'll give you telephone numbers and addresses and email addresses. And then they start calling you anyway. So the simple fact that your niece put your number and name down on the application, it's not illegal, number one. You have nothing to worry about with respect to them coming after you to repay the loans that she's not paying, because you're not a guarantor and you're not a cosigner. And the fact that they're calling you, there's not much you can do to prevent that. Now, what can you do to stop it? That's another story. You could certainly communicate with the loan company that's calling, both in writing and over the phone, and tell them not to call you anymore. And they will oftentimes comply with your request, primarily if it's in writing. So that's all we have time for today. Remember, if you have questions that you want answered on our YouTube channel, please submit them either in the comment section below or on our Facebook page, our Twitter page. And now we have an app that you can download from the iTunes App Store. And it's really a good little app because it allows you to ask your legal questions right through your phone or iPad, and then it'll go right to one of our attorneys. And either myself or another attorney in the office will write you back with an answer to your question. So thanks for joining me, and I'll see you next time.